for a couple things. Looks like we've got a retrial hearing maybe and a bench warrant. So I'm going to go over a few things. This court issued a bench warrant on March 19th, which would have been last Thursday, initially for testing positive for the controlled substance methamphetamine and the controlled substance of marijuana presented through the metabolite of THC. And then subsequently, they're also related to that. On that same day, allegedly the defendant failed to appear for testing on or about Saturday, March 14th. And what are we doing today, Mr. Harrison?
She's prepared to make admissions as to the material allegations. The only thing that might cause us some trouble is the failure to test allegation, for which she did not have any prior notice.
All right. Ms. Cruzy, am I saying it correctly?
Yes, sir.
Thank you. Please raise your right hand to the best you can. Do you swear or affirm the information testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hand. All right, so Ms. Cruzy, you were out on bond in this file, and you were ordered not to possess or use or consume controlled substances and to be randomly tested at community corrections. And it appears that you went down, signed up for testing. Is that right?
Yes.
Now, I'm told you're going to admit to violating this condition. I need to let you know that you do have the right to due process, which means you could have a contested hearing and the prosecutor would have the burden of proof to try to demonstrate that you violated your bond by violating the orders of the court. Now, failing to comply with an order of the court could be considered contempt, but the court doesn't use that power. Contempt could get you up to 90 days in jail, up to $7,500 in fines and costs, but the court doesn't go down that road. The court only looks at this as a review of your pretrial release conditions pursuant to Mission 406.106. Now, also joining us this morning is Ms. Stark from the Community Corrections. I'm told today that you're going to admit to the testing positive for methamphetamine and marijuana for violating that order and consuming that substance. If you do, you'll not have a hearing of any kind. Does that make sense?
Yes, Your Honor.
All right. And has anyone made any promises, threats, inducements, or to compel you to admit to violating your bond in this way?
No, Your Honor.
And therefore, Ms. Cruzy, is it true that on March 19th of this year, you reported to community corrections, provided a sample for testing? Right?
Yes, Your Honor.
And was that a urine sample?
Yes, Your Honor.
And did it tested positive for consumption of methamphetamine and marijuana? Is that correct?
Yes, Your Honor.
And when was it that you used that substance? Those
For
substances?
marijuana, it's been in my system this whole time. I was a daily user prior to all this, so she told me that would be in my system for a while. But the last time I used marijuana was the end of February, and the last time that I consumed meth was a day or so prior to me testing.
Okay. All right. Ms. Stark, do you know when she reported to community corrections initially? Like, when did she start the testing? Is what I'm looking.
Her first test was on March 10th, and she was positive.
Okay. And when did she, was that was her first test, you said?
Yes.
All right. Mr. Carge, are you satisfied with your proofs?
I am, Your Honor. I'll just dismiss any marijuana allegations because I know that can stay.
Okay.
But
It's okay.
Okay,
I was
fine.
gonna make through, it can stay in your
Yeah.
fat cells. But I don't want to say fat related to a woman in public, but great, now you made me do it.
yeah, I'm sorry.
All right.
Your Honor. It was a big practice.
No offense, Your Honor.
No
None
offense
taken.
Thank you. Mr. Harrison, are you satisfied?
I am indeed.
All right. The court is as well, and I find that the admission today is made freely, knowingly, and voluntarily. The court finds that the information provided in the file, as well as stated by Ms. Cruzy, is that she violated the terms or conditions. Therefore, the court finds her in violation of her bond for the consumption of methamphetamine. All right, so now becomes the question about what to do with the defendant. I note here on the felony information, she's got a charge of possession of meth, assault with a dangerous weapon, a machete, and assault, resist, obstruct a police officer. I note that the possession doesn't have any second or subsequence. And I also note that there's also a charge of fourth or child abuse in the 4th degree.
That
But
involves.
here's my point. I don't see it at a prior felonies.
Right.
Go ahead, Mr. Carnes.
That's correct. Your Honor, I think there should be a second subsequent controlled substance. She does have no, never mind. She's not eligible for 7411, but we still can't use that.
It was
She had
dismissed.
Successful 7411.
And when was that?
It was marijuana, so it was sometime.
All right. Ms. Stark, again, she had just began testing a couple weeks ago, correct?
First test was on March 10th. On March 14th, she was a no-show, and then she appeared on the 19th.
All right. Okay, Mr. Carnes, what do you want? What was your recommendation?
Your Honor, at this time, I would ask the court to remand the defendant. The reason that she is on bond for possession of methamphetamine and using methamphetamine while she's on bond. I'm covering for Ms. Carey, so I'm not going to say too much, but I'm sure if Mr. Harrison wants to make a motion with treatment plans in the future, that would be something my office would consider, but at this time, I do think a remand is appropriate.
Mr. Harrison, before I turn to your recommendation about bond, I see that we're also here today for a pretrial. And
Is that scheduled concurrently, Your Honor?
it is,
Okay.
so I don't know. So I'll ask you to fill out the court's forms for that, but do you know whether or not there is a resolution to the case today?
There is not as it
Okay.
stands right now. We are working toward that.
That's fine. That's all I need to know. All right, so now
I will fill out the sheet for you. I'm sorry. Your Honor.
it's all right. You're fine. So that means I jump ahead to the question about your position and what to do with bond.
Well, regarding bond, this case is unique to the extent that she posted a $25,000 surety bond with the court on the 4th of March, I believe, Your Honor. And that has not been obviously forfeited or called in by the bondsman or anything like that. So that would remain available to her, does remain available to her in terms of securing her pretrial release. As Mr. Carnes sort of indicated, we are working on arrangements to find a rehab placement for her. We actually have one. We just can't get the dates to line up, and we're working with Harbor Hall to get us in front of it so we can file a motion and do the proper procedure with the court. I don't know why I stumbled over proper procedure. Maybe it was the alliteration. The long shot of it is she's got a $25,000 bond hanging over her as a bondsman. And we're working on getting her into rehab. She has a concurrent case involving the same child that's a part of the incident in the current matter that she needs to attend to as well. Obviously, she could do that much better if she's not in jail. She would be staying with her grandparents. Yeah, she has a job. So
Where do you work?
I am a manager over at the 115 McDonald's. I was offered my job back when I was currently out on bond.
Yeah.
I've been a manager over there for the past 4 years now.
All right, Mr. Harrison, I already know what I'm gonna do.
Okay, I'll stop talking then.
That's all right, probably a good idea. So a couple options, Mr. Lee, and I know what I'm doing and I'm doing it for a reason. I'm going to set the hook and see if you mess up. If you do, then you just give me a reason to lock you up longer if there's a plea or a conviction. Okay. So when the legislature changed the statutes a few years ago and said that for intermediate sanctioned cells, we're supposed to start with the presumption of no jail, just probation and costs for any felony. It tells judges, if you're gonna give jail, let them see if they mess up. You've already messed up once. So I'm going to release you back out on your bond, and I will add to it that you are to enroll in the enhanced outpatient treatment program through community corrections. That's going to be a treatment program. Now, also, who posted the $25,000? Okay. Next time you go to use, going to be 25. It's a really expensive hit.
Thank you. Ron.
$25,000 is what that hit's going to cost you potentially. I'll put your bond and put you in jail. So if you do, and I'm not trying to say, oh, that guy's trying to be a real mean guy. No, I'm trying to give you incentive that before you inject it or smoke it, you go, does that look like it's worth $25,000?
I lost with my children. No.
So I'm setting the hook. Let's see if you do well. Thank you very much. Anything else, Mr. Carnes?
No, Your Honor.
Mr. Harrison?
Nothing further, Your Honor. Thank you
To
very
start,
much.
would you, oh, we did hear from you. Do you have anything else? No? By the way, she's almost wearing orange too. Disregard.
Thank
We're
you, Your
adjourned.
Honor.
Thanks.
I appreciate it.
Yep.
Have a great day.
Thank you, you too.
Okay.